Mr. President, Your Excellencies, my name is Christopher Bashara and I appear for the applicant, the State of Armenia, along with my co-agent, Glenn Kembry. I will be speaking first for 22 minutes, my co-agent will speak second for 20 minutes, and we reserve 3 minutes for rebuttal. Your Excellencies, the attack on the Bakhchar Valley Hospital was but one of 50 strikes in a regalian campaign that violated Armenia's territorial integrity and disregarded the minimum standards.
Mr. Bashara, could I ask you before you proceed any further, the claims that you're making with regard to the strikes, which claims are you making in terms of your own direct right, and which ones are you making in your indirect right, if at all, or are they both the same?
Mr. President, there is a direct injury to the state of Armenia, namely the drone strikes occurring in Regalia's territory, foremost among which was the Bakhchar Valley Hospital strike. There are also drone strikes occurring in Regalia, and we note that separate bases of standing are pleaded in relation to each. With respect to the drone strikes in Regalia, we submit that Armenia has standing on an erga omnes partes basis, which the respondent disputes at pages 1 and 19 of its written submissions. We submit...
Could I just... why erga omnes?
Mr. President, there is no identified Zetian on the compromise over whom diplomatic protection can be asserted in respect of these strikes, and Armenia has to have recourse to the doctrine of erga omnes partes. We submit that standing on this basis derives from the 1949 Geneva Conventions and the 1966 International Covenant on Civil and Political Rights, to which both Armenia and Regalia are states parties. We submit this court should find that these treaties confer a legal interest on all states parties in the compliance by other states parties with obligations under them. And this is supported by the text of the treaties. Indeed, Common Article 1 of the Geneva Conventions obligates all states to ensure respect for international humanitarian law. And as has been observed by Judge Simmer in his separate opinion in the 2005 armed activities case, one means of ensuring respect for humanitarian law is to institute proceedings in this court. Similarly, Article 2, Paragraph 1 of the Covenant has been interpreted by the Human Rights Committee in General Comment 31 of 2004 as conferring on all states parties, a legal interest in the compliance by other states parties with their covenant obligations. Now, the strongest argument the respondent has put against us in regard to standing is based on paragraph 91 of this court's judgment in the 1970 Barcelona traction case, in which this court stated, and I quote, "Human rights treaties do not confer on states the capacity to protect the victims of infringements of such rights." But in our submission, that statement goes to the question of jurisdiction, not standing. The court merely noted that many human rights treaties do not contain a compulsory interstate dispute resolution mechanism.
Could I interrupt you again? You're invoking the Covenant Committee as authority. What authority does that have? What binding character does it have for all these other states when they say every state has a right to bring this action?
Mr. President, the Human Rights Committee, its views should be ascribed great weight, as this court made clear in its 2010 Amadou Sadio Diallo decision. It is the chief interpretive body of the Covenant, and it may be considered a subsidiary source of law, pursuant to Article 38(1)(d) of this court's statute. We submit that its statements are persuasive in this regard.
Yeah, will you please share with us some state practice on action started on the basis of erga omnes?
Your Excellency, we concede there is a paucity of state practice here. And that
paucity?
There is not much, Your Excellency.
Not much or none?
There is some, Your Excellency. We would note that Australia, in the nuclear tests case, did allege that there was an erga omnes obligation not to engage in nuclear testing. That is found in the written pleadings of the parties. The court has never applied the doctrine of erga omnes or erga omnes partes, but we submit that this is the appropriate case in which it should do so.
And you know how it ended, that case?
Yes, Your Excellency, we do. Ultimately, no decision needed to be made.